So I don't know about you, but if you've dealt with medical malpractice cases, in North Carolina there's a cap on non-economic damages, and that is like 650 some thousand dollars, which is just nothing in a medical malpractice case. The amount of loss is incalculable many times. Like if you have a death or a catastrophic injury, those are so-called non-economic damages. They can't be calculated in an economic nature. They're not like lost wages or some sort of lost, money that comes in of some kind, or something that's also set out by the statute. But it's just such a fucking arbitrary number, 656,000 something. And it took effect on January 1st of 2023. But it's just so draconian and harsh. That's redundant, but it's so harsh in its effect. And it really hurts these types of cases, and it discourages lawyers from taking these cases. However, if you can get beyond that, if you can establish gross negligence, which is just a higher form of negligence, basically that was beyond the pale of failure to exercise reasonable care. It's a higher standard of proof. If you can establish that, then you can get beyond this arbitrary cap, which has just basically been bought and paid for by the insurance industry. They've lobbied North Carolina. They've convinced people that or medical malpractice cases are somehow a bad thing. They aren't, quite frankly. It's one of the few ways that you can police doctors and get rid of bad doctors by suing them out of existence. And there are plenty of them, and they screw up and they get covered for, and they ruin lives. They cause people to not survive anymore, and they just cause many, many problems. And there's no way to check them without having the ability to hire a lawyer and to file a lawsuit to police doctors, essentially. And so this cap is arbitrary. I have to deal with it. It's very hard to get past the gross negligence argument, but it can be done because a lot of the time the facts are so egregious and these providers are so negligent and so despicable that you can actually show it. But it can be hard to do, hard to actually show what happened and to have proof of it. You may have a pretty good idea that that happened, but that's not good enough to get you to gross negligence. So it's a harsh doctrine. There are ways to get around it, and you have to have a creative lawyer who thinks about ways to do this and comes up with good ways to do it. Otherwise, your case is going to be capped at, if you've got only non-economic damages, or it's going to be limited because of the harsh nature of North Carolina's medical malpractice law, which heavily favors the medical industry.